Good afternoon from Dallas, Texas. Thank you for joining us. Today we are going to be covering a topic with a lot of moving parts. We've got a lot to discuss. Excited that you've decided to join us. Today's webinar will be about transgender and non-binary rights and discrimination in the workplace. My name is Tracy Wolf. I'm a partner in Husch Blackwell's Healthcare, Life Sciences, and Education Group. I'm a Texas board certified labor and employment attorney. I concentrate my practice in employment law. I handle litigation as well as client advice. I also do commercial litigation. Before we begin today, I'd like to cover a few housekeeping matters. At the bottom of your screen is the audience console. There are multiple application icons for your use during today's program. We also have a question box. We are hopeful that we may be able to get to some questions. We do have a lot of materials to cover in our hour, so can't be sure of that. But if you have questions, please do not hesitate to submit them to us. If we're unable to answer them during today's presentation, we will follow up afterwards. There is a PDF of our presentation available in the program materials folder, and this program has been approved for continuing legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of today's program, be sure to complete the short survey. We want to hear your feedback. We want to hear what interests you, what you would like to hear more of for our future programs. And I will start by saying that in the future, we are planning to cover more issues pertaining to DEI issues and do this as somewhat of a series. Coming up very soon will be a similar program on reverse discrimination. And just to go through today's agenda, to let you know what we're here to discuss today, we plan to provide a historical view of the case law interpreting Title VII as it relates to transgender and non-binary rights. Most of that is going to be done by my colleague, who I will introduce just shortly. We're also going to provide an overview of the executive orders relating to DEI-related issues, with an emphasis on transgender and non-binary individuals. We're going to try to make some predictions and discuss how the current law interacts with case precedent and also how these executive orders will fit in. With that, I think we do want to say also what we will not address. The purpose of our presentation today, we're not going to go into our opinions, our thoughts. This is supposed to be information. A lot has happened under the new administration. We've seen a lot of executive orders issued, and we're seeing some activity in the U.S. Supreme Court that we want to discuss. So that is going to be today's focus. But joining me alongside is Carol Barrera. She is one of our associates here in the Dallas office of Husch Blackwell. She also focuses her practice on labor and employment litigation and advice. She enjoys representing clients in complex disputes. She also collaborates with businesses to develop proactive policies aimed at minimizing legal risk and helping them avoid future litigation. During law school at Texas A&M, Carol actively participated in mock trials, refining her litigation skills and gaining confidence in the courtroom. Her judicial externships further sharpened her understanding of court procedures and the importance of precision in legal work. And she comes here today. I believe this may be Carol's first webinar. I'm very excited to be speaking with her today, and I'll go ahead and let Carol tell you a little bit about historical aspects of this issue. Carol?
Thank you, Tracy. All right, so today we're going to start with an overview of Title VII and just the law around gender identity. We're going to start with again, Title VII, the Civil Rights Act of 1964. This is the cornerstone federal law that prohibits employment discrimination for employers with more than 15 employees. Title VII makes it unlawful for employers to discriminate against an individual because of sex, among other categories. So for a long time, there was uncertainty and debate over whether discrimination against a transgender person was considered because of sex. Some interpreted the word sex to mean only biological sex, while others said that treating somebody adversely for being transgender is inherently sex-based. In 2012, there was a case named Macy versus Holder, where the EEOC confirmed at that time that Title VII did cover gender identity. In their decision, they cited the Supreme Court case Price Waterhouse versus Hopkins, which was from 1989. It was a landmark decision on the issue of employer liability for sex discrimination. In that case, the employee sued her former employer, the accounting firm Price Waterhouse, and she argued that the firm denied her partnership because she didn't fit the partner's idea of what a female employee should look and act like. The employer in that case failed to prove that it would have denied her partnership anyway, and the court determined that the employer's actions were considered sex discrimination under Title VII. So in Macy versus Holder, the EEOC emphasized that ruling and emphasized that punishing somebody for failing to meet society's expectations for men or women is discrimination based on sex stereotypes. So in 2012, the EEOC used those cases to interpret Title VII to protect trans employees, but there's still conflicting interpretations in the case law nationwide. So that was until really June of 2020, the Supreme Court ruled that firing or discriminating against someone for being transgender or gay violates Title VII. And I want to take a couple of minutes to really focus on understanding the Bostock versus Clayton County decision, because it really sets the stage for everything we're talking about. And in theory, it should probably give us some insight as to what the future could hold. So in that case, Justice Gorsuch wrote a 6-3 majority opinion joined by Chief Justice Roberts and the 4 liberal justices on the court. It was significant because conservative justices embraced a textualist argument that recognized that LGBTQ+ protections. In their opinion, the court applied a purely textualist approach that the statute explicitly bans discrimination because of sex. So if an employer would not have taken action but for the employee's sex, that is prohibited. In the LGBTQ+ context, firing somebody because they come out means their sex assigned at birth was the deciding factor, which is, in the court's opinion, exactly what Title VII is written to outlaw. However, the decision has left a few open questions. It didn't resolve religious liberty considerations, including existing exemptions for religious organizations and possible defenses under the Religious Freedom Restoration Act. It also didn't address specific employer policy questions like how employers should handle dress codes, restrooms, locker rooms, or pronouns. Those weren't part of the case, so the court essentially said, we're not tackling those things right now. But Bostock still had a really big impact. Before it, only 22 states and DC explicitly protected gender identity in employment. And after Bostock, Title VII's protection automatically applies as a baseline protection nationwide, even in states that don't explicitly cover this in their own laws. So that decision was a big expansion of rights for the LGBTQ+ community as a whole. So just to review the development since 2010, before 2020, courts were split on whether the word sex under Title VII included gender identity. Now the debate is somewhat settled with the Bostock decision in 2020. And after Bostock, federal laws treat gender identity discrimination and sex discrimination under Title VII a little bit more broadly, extending that, again, protection nationwide. So following Bostock, the EEOC made it very clear that sexual orientation and gender identity were protected under Title VII. As we discussed previously, in reality, the EEOC had really already recognized those protections before that case, but the Supreme Court ruling gave it firm legal backing. Practically, if somebody believed they were hired or harassed for being transgender, they can file an EEOC charge just like any other sex discrimination complaint. Now, in 2021, the EEOC did go a step further by issuing guidance for employers. It released a document explaining Bostock's impact, addressing key areas like bathrooms and locker rooms, dress codes, and pronouns. But as we will get into shortly, that was struck down later on in certain states. Also, just a quick recap of what the Biden administration had done. The Biden administration had strongly supported these developments and the decisions of the EEOC up until that point. On his first day in office, President Biden signed an executive order that instructed agencies to enforce anti-discrimination laws to protect LGBTQ+ individuals wherever possible. And this varied across different areas like education, healthcare, housing, and employment. So this approach pretty much expanded Bostock's protections beyond just the workplace. However, that order was rescinded on January 20th, 2025. So moving ahead to 2024, the EEOC updated its workplace harassment guidelines, which included examples of LGBTQ-based harassment. Of course, there has been some pushback. Texas, for instance, did sue the EEOC in 2021, arguing the agency went beyond Bostock's requirements, and now the political landscape has also shifted in Washington. Those enforcement priorities could change. But really, unless the Supreme Court overturns Bostock, the discrimination based on gender identity does remain illegal, and employees can still file charges on this basis. I do want to also add that in March of 2025, the EEOC and DOJ did release guidance clarifying that while DE&I programs are also valuable, certain practices can violate Title VII if they discriminate based on protected characteristics like race, sex, or national origin. So needless to say, this was just last month. The law is still developing, as we know. Now, I just want to take an opportunity to show everybody this map. This map shows how different states handle LGBTQ+ employment discrimination. So the darker states have comprehensive protections. The lighter ones had little or none before Bostock. And the orange hatched states like Tennessee and Arkansas not only lack protections, but also prevent local governments from creating their own. So they have taken action to actually prohibit those local governments from passing anything to protect on a more local basis. So currently about 21 states plus DC explicitly protect gender identity and sexual orientation under their employment laws. I call these broad protection states because they often have different coverage thresholds. So some will cover employers with just 1 to 3 employees instead of the 15 that the federal laws require. And some may allow for additional remedies or direct lawsuits, in state court. So I want to take a moment to kind of highlight some of the cases that have come about after the Bostock decision. The first one is state of Texas versus the EEOC. This case really underscored that Bostock might not actually cover things like pronoun usage or bathroom policies. The Texas court said that this is where the Texas court said the EEOC's guidance went too far on these issues and officially struck it down. So for employers, it creates questions about how to handle transgender accommodations, since there's no longer really a clear EEOC directive on this point. The next one is Bear Creek versus Braidwood. Bear Creek and Braidwood versus the EEOC. So this was regarding religious employers who preemptively sued. They claimed that they shouldn't have to hire or retain LGBTQ plus workers because it conflicts with their faith. The Fifth Circuit agreed, saying that forcing them to comply with Title VII would violate religious freedom under the Religious Freedom Restoration Act. The ruling is limited to these specific plaintiffs, but it could signal a broader shift. In the Fifth Circuit, religious objections can potentially triumph over LGBTQ plus discrimination claims if the employer can prove a substantial burden on their faith. Third case here is Klug versus Brownsburg. On the flip side, Klug, a teacher in this case, wouldn't use a transgender student's chosen names for religious reasons. The Seventh Circuit said that denying trans students those names harmed and stigmatized them, so the school wasn't required to accommodate the teacher in that case. Even though the case was sent back to reconsider a tougher undue hardship standard, it still kind of shows that if an accommodation undercuts inclusion or causes real harm to an individual, courts can still side with the employer's policy protecting LGBTQ plus rights. Lastly, Adams versus St. John's. Now, although this is a school case under Title IX, it does reveal a crack in how courts read the term because of sex after Bostock. The 11th Circuit in that case upheld a policy requiring a transgender boy to use the girls' bathroom, basically holding that sex means the sex assigned at birth for bathroom purposes. That doesn't directly control the workplace, but again, it could influence how courts in certain jurisdictions tackle restrooms or facility uses when it involves transgender employees. So as you can see, there's somewhat of a split in how courts are interpreting. One of the themes that we have is that's kind of been highlighted is status versus conduct. So the court seems to have drawn a distinction in some cases between status, so being transgender, or conduct, which are workplace rules affecting transgender employees. Employers could argue, well, we're not discriminating based on transgender status, we're just enforcing a neutral policy. Although there are several courts and the EEOC in the past has disagreed with that perspective. And obviously other courts can reach different conclusions on that. So this is evolving area of law.
And Carol, thank you so much for the overview. I know that there's a lot out there, and this in no way is intended to be comprehensive. I've seen some mention of cases in other circuits, whatnot. This is meant more as an overview, and I've seen folks asking for the Ames case. I guess that's kind of really on the forefront of everyone's mind right now. And I know right now we're waiting for the Supreme Court to issue a ruling on that. It was argued back in February. People are thinking that we'll probably hear something by the summer, and it's definitely at the forefront of everyone's mind. And a lot of guesses on how the Supreme Court may rule, who may issue the opinion, whatnot. A lot of thoughts going into that. But why it is important and how it relates to our topic today, of course, it does involve a plaintiff who is a heterosexual cisgender woman who claims she was discriminated against in favor of an LGBTQ colleague. And I've seen a comment about the use of the term reverse discrimination. I don't really know the origin of that, but we see it often, and it's come part of our parlance. That's something that would be interesting to look into. Thank you for the individual who sent the comment on that. It is going to likely give us a lot of insight into what we can expect going forward. I know that it's one of those issues that it's going to give us some insight to how to deal with the executive orders too, and what we can expect in that context. One of the things with Ames is in the event that the Supreme Court does not adopt the background circumstances test, which a lot of people are predicting to be the case because of how Bostock was handled from the textualist view, meaning the ordinary usage of the term. That's going to potentially open up the door for these reverse discrimination cases. And I think a lot of people are, we are definitely interested to see how that comes down, how that affects not only litigation and how companies have to manage their businesses moving forward, but also what we can expect to see from the EEOC and other agencies. It's definitely something that's going to change things. I think that many are expecting a rejection of background circumstances. Legal and analysts say that likely to say Title VII protects everyone equally. A straight woman's claim is the same as someone who is not. So that's definitely going to be interesting. And I notice we're probably well overdue for a polling question. So I'm going to ask everyone to take a moment to let us know, how would you rate your organization's current readiness to respond to employee questions about transgender rights? We'll give everyone a couple of minutes to look at that. We've got about 50% responding. We'll give y'all another 30 seconds. All right, let's see what we have as our results. It looks like we've got about 71% responding. Some feel not prepared at all. Some feel fairly well prepared. I think the 42.7% that go with somewhat prepared, that's probably where a lot of people fall. The people that are completely prepared, my hat's off to you. That's a good feeling, I'm sure. Let's talk a little bit about the executive orders and the and what we're going to be overviewing with regard to those. This section is going to focus on executive orders under the Trump administration. What we're going to talk about is basically it's a list of those that have potential impact on DEI programs and issues. We're going to look at women's sports and transgender participation, federal gender policies, and DEI programs. Just so you'll know, future programs are going to discuss this. We are not going to deep dive. This is, again, meant to be an overview. First off, we'll do another poll. Please let us know how many executive orders did President Trump sign on his first day in office? And no Googling it. We'll give everyone about a minute to respond. All right, we've got about 65%. Let's see what everyone said. Well, I think we have a group of people who definitely watched this issue. Some were pretty close. It wasn't 5. There were a flurry of them. Was not 15. Was not 50. 26 is the correct answer. And let's talk about 3 of those that are related to DEI issues that were signed on January 20th of 2025. We'll start off with the first one, which is called the Ending Radical and Wasteful Government DEI Programs and Preferencing. I'll start off by saying this is applicable to federal agencies and not to private industry at all. This particular executive order, I know a lot of clients have asked about that and what to expect in that realm. That again is not something we're going to dive deep into today, but definitely a topic that will be covered in the future. But essentially what this executive order does, it terminates virtually all federal diversity, equity, and inclusion programs across the government, directs the U.S. Office of Personnel Management and the U.S. Office of Management and Budget to eliminate, see a typo there, DEI mandates and rescinds orders. It specifically, and I know this is one that Carol referenced in her presentation, it specifically rescinds Executive Order 13985 on advancing racial equity. Also bans practices such as listing pronouns in communications, primarily on signature blocks. So if you're working for a government agency, that's something that this order would not allow. Also, essentially ends agency equity action plans and affirmative action initiatives within the federal workplace, and purpose stating it's halting race or gender-based preferences in government programs. So this was a fairly, before moving on, a fairly expansive kind of overriding one, came early in the administration, as early as possible on the very first day, something that we understand was anticipated. Also on day one, Executive Order 14168, which is called Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. This is the executive order. A lot of articles have been written about this, a lot of podcasts, a lot of talk. It recognizes that there are only 2 sexes, male or female, basing that on immutable biology, and it rejects the concept of gender identity as a basis for policy. Agencies were directed to enforce laws using these sex definitions, removing references to transgender identity, and cease any policies accommodating gender identity. So for the purposes of our topic today, this is a highly significant executive order and changed a lot of things. Specifically, it revokes multiple Biden-era protections, such as the Executive Order 13988 on gender identity non-discrimination, and dissolves White House dissolves the White House Gender Policy Council. So it's a complete reverse from what we had seen during the prior administration. And the third executive order in this topic, or related to this topic, that was entered on the first day of the new administration is Executive Order 14170, and that is called Reforming the Federal Hiring Process and Restoring Merit to Government Service. This executive order is recognized as overhauling federal hiring to a strictly merit-based system and barring any consideration of demographic preferences. Prohibits using factors like an applicant's commitment to DEI or gender identity beliefs in any hiring decisions. And in practice, this particular executive order eliminates the diversity recruitment efforts or any race, sex conscious hiring, mandating that federal jobs will be filled without regard to race, sex, or other identity attributes. This concept is referred to in the order as, quote, restoring merit. Day 2, there also a related executive order was released, Executive Order 14173, which is entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This particular order targeted DEI initiatives in both the government and private sector. It directs attorneys general to identify and pursue egregious and discriminatory DEI practices in companies. And on a side note, I know that there have been several letters issued and orders from the EEOC. We're not going to dive into that today. We do have that coming up in a future presentation. So going back to our overview, the order revokes Executive Order 11246. That's from 1965, Lyndon B. Johnson's administration, which required affirmative action by federal contractors for using race, sex, and other identity factors in employment and on contracting decisions. So it is a pretty significant difference from what we presently understood and what the federal government in particular, their requirements in hiring previously were. It refers to itself as establishing a policy of colorblind, sex-neutral, merit-based treatment, characterizing many DEI and affirmative action programs as unlawful discrimination. Also in the first month, and this is one that we've seen with regard to the military. It's also a reverse in prior position. 14183 is called Prioritizing Military Excellence and Readiness. It reimposes a ban on open transgender individuals in military service. It declares that expressing a gender identity incongruent with one's biological sex is incompatible with the military standards and unit cohesion, deeming it harmful to readiness. It requires the Defense Department to issue new policy excluding transgender individuals, effectively rolling back the prior administration's inclusion of transgender service members. Also, it states that gender dysphoria or gender transition is a disqualifying condition for military service. Finally, and the last one in January was Executive Order 14187, which is called Protecting Children from Chemical and Surgical Mutilation. The order severely restricts access to gender-affirming health care for transgender youth by leveraging federal funding. It declares a policy whereby the U.S. government will not fund or support any transition interventions for minors. The order directs federal agencies to enforce this order by withholding federal funds from hospitals, clinics, and medical programs that provide puberty blockers, hormones, or surgery to transgender minors. One more in January. And this is 14190, Ending Radical Indoctrination in K through 12 Schooling. And this is one that I know has drawn a lot of articles also and a lot of criticism. It prohibits in K to 12 schools any teaching of materials considered anti-American, essentially defining those as anything subversive or anything promoting gender ideology or critical race theory. Law enforcement is directed to conduct investigations of education and education-related institutions suspected of involvement in the instruction, advancement, or promotion of gender ideology or discriminatory gender equity ideology, declaring these laws or these types of practices to be anti-American and subversive. Also directs law enforcement to criminally prosecute any teacher who unlawfully facilitates the social transition of a transgender minor. This one, I'm going to go into a little bit more detail on this one because of the detail it goes into. For one thing, it restricts referencing any student as non-binary, using preferred pronouns or preferred name, finds it unlawful for psychiatric counseling to any such individuals. And it's also essentially sponsors the segregation of sports teams for individuals differing from those on the team from their assigned sex. The stated penalty for violating this would be the revocation of federal funding. It reinstates the 1776 Commission, an advisory committee established in September of 2020 under the Biden administration to support patriotic education. So this actually, the patriotic education, the 1776, it reinstates. That was actually terminated during the previous administration, created in the administration before that. So it's essentially bringing back that commission from the administration prior to the last. February 5th, and one we've seen a lot of news coverage on, and this one is entitled Keeping Men Out of Women's Sports. It's Executive Order 14201. It prohibits transgender women and girls, whom it refers to as biological males, from competing in female sports categories in any school or college receiving federal funding. The order directs agencies to enforce Title IX based strictly on biological sex, ordering that schools allowing trans athletes in women's sports will have their federal funding revoked. The order cites the protection of women's safety and fair competition as justification. Also on February 5th of 2025 is an Executive Order 14202, eradicating anti-Christian bias. This one, and I'll take just a moment, this one establishes a task force to root out alleged anti-Christian bias in federal agencies with implications for LGBTQ+ policies. The order positions certain prior supported policies such as discriminatory towards religious beliefs and calls on agencies to end those policies. For example, it criticizes the previous administration for actions protecting LGBTQ rights, like enforcing gender identity, non-discrimination, and foster care, as particularly infringing upon religious liberty. And you recall in the first part of the presentation, one such case was discussed by Carol. This is something that may create a change in the case law, something to carefully watch, and something we have been watching. Oftentimes, religious views can conflict with other views, particularly those of the LGBTQ community. And it may also result in greater religious exemptions for such, and that would also, will tie into how that relates also to Bostock as we move forward. And the most recent one, and this is one we saw just looking at the dates, I guess it's been less than a week, Executive Order 14278. This one is cutting edge, not precisely on point, but its impact will could definitely change case law and change how we practice if that is not in any way challenged or if it is upheld by the courts. It's called the Restoring Equity of Opportunity and Meritocracy. It eliminates the use of disparate impact liability in federal civil rights enforcement, meaning agencies will no longer treat neutral policies that yield statistical disparities as proof of discrimination absent intentional bias. And those of you who have experience in the employment law arena or have had employment issues in your business are probably familiar with the disparate impact liability theory. It's not a direct or intentional. Oftentimes it's based on the numbers, and because of the enforcement and how it's enforced, it has an impact that is in some way discriminatory. And that applying that across Title VII and Title VII cases would indeed, for legal standards, change how companies are able to defend, how plaintiffs are able to plead such cases, and also how we potentially will advise. A lot of times policies are looked at from the neutral standpoint to make sure that their impact and how they are applied would not result in potential discrimination or a violation of Title VII. In the federal in the federal arena, this is essentially by this executive order being deprioritized and rescinded. So it's really interesting how this may interact and how this may and also influence all categories that fall under Title VII, including transgender and non-binary rights. It is a major legal shift. Will also affect potentially Title VI, Title IX, and fair housing. In practice, the order may undermine many DEI initiatives that rely on statistical disparities to drive reforms, and embraces what they call a colorblind, merit-based approach. Now we get to the aftermath. And I'll also pause for a moment. Carol at any point may want to come in and add some commentary. But there have been, and we actually, for today, purposes of today, looked at several lawsuits and challenges. I know that recently, one particularly in the Fourth Circuit, a challenge was overruled. But we're seeing a lot of that all across the board, and people have asked, does Congress have the ability to invalidate these, and do the courts have the jurisdiction to overrule these executive orders? And just from a 3,000-foot view looking down, we'll say Congress has the ability to invalidate an executive order through legislation. But I think it is very important to note that the executive branch still maintains veto power, and in order to override a veto, kind of reminds me of the Schoolhouse Rock that I used to watch as a child. To override a veto, you've got to achieve a supermajority, which is 2/3, and that's kind of difficult. That's a very high standard. With regard to courts, courts have the power to make judicial reviews, and we've seen many of those recently. A court may strike down an executive order on the grounds that the president lacked authority to sign it. Also, if there's a finding that it's unconstitutional. So I would imagine in the months ahead, we've already seen, and we'll continue to see a lot of challenges. And that, in addition to waiting for the Supreme Court to come out with a ruling in Ames, it's going to change a lot of our discussions moving forward. And I think right at the beginning, this presentation, we're only touching the tip of the iceberg. And with that, I think it's probably time for another poll. Do you believe existing anti-discrimination laws, like Title VII and the state law equivalents, still protect gender identity rights despite the new executive orders? We'll go ahead and give everybody a couple minutes to discuss or to answer. All right, it looks like we've got about 70% responding. Let's see. All right. About 35% believe that the existing anti-discrimination laws still protect gender identity rights. 11% say no. 14.8% say partially, and some say depends on the jurisdiction. That's 6.8%. We've got C and D, 31%. And my colleague has pointed out to me it's a very good time to discuss the issue of the current status of the case law and these executive orders and what it really all means. And we do, at the offset, we discuss the fact that we are not here to offer opinions. We're here to discuss the law and the current status of the law. And Carol spoke very eloquently about Bostock earlier on in this presentation. And we get a lot of questions. Is Bostock still good law? Absolutely, yes. And that is all companies are going to be required. This is, it's the law coming from the U.S. Supreme Court. And we discussed the individuals who are the justices who had authored and concurred with that opinion. And the reasons cited, and I don't know, if all of you have read the opinion, I think it's definitely worth reviewing the textualist approach and the use of the term sex, and whether or not that applies beyond just gender or any other determination, and whether that would extend to the transgender and non-binary individuals. And they found overwhelmingly the answer to that was yes. And moving forward, I think that is going to remain the status of the law. If I don't have a crystal ball, but when the Ames opinion comes out, a lot of commentators feel it's likely that the textualist approach will also come into play. And I think that's a strong academic way, and that's how the justices have looked at it from an academic perspective. And I think that is going to offer us a lot of guidance in the other issues, and also extending it over to the executive orders. Something to be clear on, a lot of the executive orders apply only to the federal government. I know a lot of individuals are thinking that this can extend over to the private sector, and a couple of them definitely do, and I think it is some guidance for what to see, but it still does not overturn or change the holding in Bostock or the other progeny in cases that have recognized those rights. I don't think that is going to be changing at all. What it is changing is whether or not the use of that sort of information and having a preference in hiring practices and how that's applied at schools. And those are kind of separate issues, but somewhat related and perhaps guidance. But looking at Bostock and other decisions from the academic standpoint and how they were decided and on what that was based, that is still good law. And I'll pause a moment to see, Carol, did you have anything you wanted to add on that point?
I don't think, nothing off the top of my head. I think you covered it all.
I hope so. And again, to our viewers today, in no way are we meaning to add any opinion. We are here solely to state the basis of the law and how we understand it right now. And just like everyone in the audience, we don't know exactly what the future holds. These are very interesting and exciting times. A lot of change. We get a lot of questions, and that's one of the things that our team has kept a finger on the pulse to understand and to be prepared to make decisions and to also offer advice. And very different times. Things are definitely changing a lot. And with that, would like to, making sure everybody's still following us, want to make sure that or get some input and do a poll. From today's webinar, what topics most warrant a deeper dive in your opinion? And we do really want to hear from you. These are, they're difficult topics, and I will represent to you that Carol and I put a lot of time and thought. We wanted to present a survey and just let everyone know what is there, what is out there, so they can have a deeper understanding. Let's see. Okay, 61% want to hear all of the above. Well, yeah, I think we've kind of, I know people want to hear more about Bostock, and we will probably discuss that more, but yeah, I think based on the opinion, I think in reading the opinion, we kind of are able to better see where that's going. But EEOC guidelines, that's definitely something we will be watching. Future executive orders, we've seen a lot of them. I don't know how many more we will see, but as they come up, we will certainly analyze and be able to recite what they are, and how to comply with them. And that's one of the most important things for employers in particular, is to make sure that you remain in compliance with the law. And it is difficult when the law is changing, of course. So I think it is very important to remain cognizant of these executive orders, to keep up with the news. The EEOC's guidance, as of late, I've not gone on the site in the past week or so. I know that there were some changes and some things that I'd become accustomed to that have changed, that are moved from that site. But I do think it's important to be aware of the EEOC guidance. Of course, we all know that courts don't always agree with the EEOC, but I think that is a good thing to be aware of and at least cognizant of when you're enacting policies and procedures and making employment decisions and hiring decisions. It's important just to have the awareness and to think those matters through. And with that, I see we have a lot of questions, and we will be reaching out. I don't know that we have enough time to, and some of them are very, very complex questions. And I thank you to those who submitted questions. You'll give us something to think about, and we will be reaching back out to you. We greatly appreciate it. And with that, I think we are going to give you about 5 minutes back. Again, thank you for taking the time out of your day to come and hear us talk. We really appreciate y'all. Have a wonderful afternoon.
Thank you, everyone.